Good morning, WTOB listeners. This is For the Record with Greenwood Law. I'm Dylan Greenwood along with Harold Eustache. And we're here on what's going to be our final episode of For the Record with Greenwood Law for a while. We just decided to back away from this for a little bit. What our listeners don't know is that my mom actually passed away back in September. And she was an integral part, not only in my life, but in here at our firm. And she has been deeply missed. And it's something that definitely played in our decision to do that and to back away from this for a bit. But we have very much enjoyed our time here on WTOB and appreciate everybody who has listened and been a part of all this. But we just wanted to let everyone know out there that we don't necessarily expect or hope that this is going to be a forever thing. It's just for right now. This is the way it's going to be. But
it is, and that we encourage everyone that's listened to go back and listen to some of the stuff that we have. If you haven't subscribed to our channel on YouTube, go ahead and do that, or our Facebook page, and you can find some of these old episodes, and each one is labeled, so you'll be able to maybe get some insight on some of the issues in criminal law if you do that.
Right, and every episode here on For the Record with Greenwood Law, we finish off with our Greenwood Law Bill of Rights. And we're going to start our episode today with Greenwood Law Bill of Rights. And we're going to break it down. Just why do we tell you these things at the end of every single episode? And we're just going to go through them one by one. And so the first thing on the Bill of Rights, Harold, is I will not represent myself in a court of law. And, there's that old adage that, the person who has themselves for a client is a fool. Why is that, Harold?
There are a lot of reasons. I mean, one of the things we talk about when you first go to law school, you realize just how involved and just how complicated and complex the law is, and how much it takes, to become an attorney. Mm-hmm. And even when you are an attorney, like we both are, there are so many different types of attorneys, right? Mm-hmm. And so as attorneys, we still would use attorneys to do things in our life
Absolutely.
that we would need attorneys for. So we're saying that as lawyers, we would hire counsel for various things that we would need, just as anybody else would. But in the context of a criminal case, it is of the utmost importance to have counsel. Our founders recognized this. It's embedded in our Constitution and Bill of Rights, as far as a person having the right to have counsel. Now, of course, anybody can represent themselves if they want to, and we see that all the time. When I started out as a prosecutor, I would have many trials against people who represent themselves, what we call pro se defendants, and generally they were at a massive disadvantage, and not knowing the rules of evidence, not knowing the law, and all sorts of other things. You put yourself at a massive disadvantage. So we say this because whether or not you have an attorney that you pay for, like us, or a court-appointed attorney, either way, you need to have counsel to speak on your behalf. It's just important. It's one of those things in life too. Sometimes, if you are, if you're trying to tell your side of the story, it's different when somebody else is representing you and saying, "Here's on your behalf," and advocating for you, as opposed to the actual person doing it.
Right, because there's a lot of different things that get rolled into that, Harold. Like you just mentioned, knowing how to present certain things, just knowing the rules of how to set foundations for how to present things. I don't know how many times we've seen pictures from somebody or whatever else, and they go, well, I'll just show these pictures to the court and they'll see that I wasn't involved in such and such. It's like, those pictures don't necessarily come into evidence unless certain things are brought out on testimony. You've got to lay foundations for stuff. Also with that is we as attorneys know generally what arguments make a difference in a certain case, and how those arguments make a difference to the people you are making the arguments to. Judges, DAs, they're all human beings. They're not robots. And as much as we want there to be uniformity and outcomes in the criminal justice system, and we want there to be fairness across the board, these people are still human beings, and they have different things that impact them differently. There are some people out there that, as judges, that things with animals impact them more. It's a stronger impact than it is others. There's some people that anything involving a child, impacts them more than it might impact another judge. And just knowing how that plays out, and knowing those different personalities and everything else, that could be a very big deal in a case, and can save time, money, active time versus probation. There's just all sorts of things how that could play out. The other thing that I think is important to think about when not representing yourself in a court of law is when you are the person at issue in a case, whether it's criminal or civil, there's a lot of emotion wrapped up into that.
Yeah.
There's a lot of money wrapped up into that. There's a lot of everything wrapped up into that. Having a person that, while they represent your interests, but has the ability to step back from that emotion, step back from all those things that have you wrapped up in the case, and have usually a more level head, that can be of a great benefit to somebody.
Absolutely. There's so many times where you've seen somebody, representing themselves, and they want to advocate, but there's a lot of passion. And, just like anything else in life, when somebody is explaining something or advocating something, sometimes it's hard to really parse out what they're saying because, their emotion is showing through. And another thing with somebody representing themselves, even, in a trial, or in a hearing in that capacity, they could incriminate themselves in ways, even in the trial, that they're not sure, that they don't know that they're doing.
I've heard it so many times. I know you have too. Of somebody starts talking to a district attorney in court, or they open their mouths in front of a judge because they want a bond set or something, and they go, "Well, yeah, I did hit her. I hit her good, but you know what? She was talking back to me about such and such and such and such." And you go, "God, it doesn't matter. It doesn't matter what she said. It doesn't matter. You just admitted to everybody in open court that you hit this person.
Right.
And you've basically given them a statement that they can and will use against you in that court of law that you're standing in there at that moment in time."
Exactly.
And, with counsel, hopefully, now I've seen it happen in spite of counsel when somebody just really wants to get their story out there. But with counsel, more likely than not, they're advising you to not say anything.
Yes.
And that is your right to not say anything. And typically speaking, is a lot better for someone's attorney to speak on their behalf in situations like that. The second part of our Bill of Rights, Harold, is a bit broad, but there's a reason for it. We say, I will not do law enforcement's job for them. And there's a lot of ways that people can do law enforcement's job for them. We talk to a lot of people who are being investigated for certain things. And they come and talk to us and they go, "Well, this detective, this investigator, they're contacting me and they're telling me that, I just want to talk. I just want to talk about things. I just want to get, your side of it. I just want to, it seems very innocent." And what we have to tell people all the time is that, that's in an effort to get you to come talk about yourself.
Right.
And a lot of times those statements that you make can be self-incriminating. I know in that respect, and I know we address this in other parts of our Bill of Rights too, but it is always a good idea to consult an attorney before anything like that, because a lot of times people think that they're doing the right thing or they're going to mitigate something by having those interactions with detectives that they're going to just talk their way out of it, right?
The way people's minds go is that, well, they're saying that, they just need to hear my side. And a lot of times people want to tell their side, especially on something that's emotional, or when they're being accused of something. It's the natural reaction to say, I want to defend myself. I want to say, what my side of it is. And they think, I'm going to talk to this detective who seems impartial, and then they're going to hear me out. But really, what you're doing is you're helping build a case against yourself. For example, if the detective says, well, there's an incident at this club, on March 9th, and we just want to talk to you about it. Well, if you haven't talked to the detective, they don't necessarily know that you were there. They don't necessarily know, what happened. They may have some evidence or maybe have some testimony from others, but they don't have it from you. And you think you're explaining, well, I was there that night. Yes, I know the person in question. Yes, this other thing happened, but you're giving them pieces of the case.
Right. You've at least at that point placed yourself at the location this was going to happen, had an interaction with whoever's at issue with the case. I mean, you've built up a good percentage of what they were looking for just right then and there, and they're trying to fill in the pieces from that point forward, whereas they wouldn't have been able to confirm that before. The other area that I think about this frequently, and it's not necessarily a true statement as it would be in that we would consider like testimony or something that would come out as someone's statement in court, or field sobriety tests for DWIs.
Yes, I agree. Yeah.
That is a way that if you're consenting to field sobriety tests, you're helping do law enforcement's job for them. There are times during a DWI stop that if you get out of the car and you are so fallen down drunk that you cannot stand up straight, and we've seen that. Where somebody's just stumbling out all over the road, whatever it may be, you can't, you're talking like this and you can't get the right words out, stuff like that, more people are going to be able to look at you and go, dude, you're impaired. More often than not, in a DWI, it's a lot closer call than that. A lot of people are able to get out of their car and look halfway balanced. But then these field sobriety tests are meant to look specifically at how your balance is when your attention is divided and when, you're not just looking straight ahead at the horizon or at the road. That's a different thing that your body has to do.
It is, and it's all built to be used against you in court to build a case against you.
Right.
That's kind of the theme, of this whole Bill of Rights is, don't build a case against yourself. The Constitution doesn't require it. It just doesn't.
At all. It's the state of North Carolina's job to come up with a case and to prove that case against you beyond a reasonable doubt.
That goes into our third one, yeah.
Yeah, and it's the same for the United States government in federal court. They have to investigate and come up with the case and then prove that in a court of law beyond a reasonable doubt.
That goes to our third one, which is I will not make statements when stopped by law enforcement. And people think, when they hear that, they may think, well, why wouldn't I make statements?
Well, there are a lot of reasons why you wouldn't make statements, Harold, because statements, if you ever watch Cops and,
I love Cops.
Yeah, and I mean, they're just Mirandizing people on the spot, which, that's an interesting topic because that doesn't necessarily happen in every case. But when you're making statements, anything that you say can and will be used against you. I promise any statements that you make when you're stopped on the side of the road, when you are having an interaction with an officer that leads to something more, I promise you that is getting written down in a report or is being recorded on some sort of body camera.
And a lot of times those statements at the initial stop are the most important statements used in a trial, in courtrooms, for your case. And that's why we say this. I will not make statements when stopped by law enforcement. As you guys have probably heard, you have the right to remain silent. You know, and don't take that right as you know, an affront to law enforcement. It's not. It is your patriotic right. It is your American right to have that right to silence. That was one of the things that our founders and framers demanded. You know, the Constitution wouldn't have been ratified without those Bill of Rights. And if you look at those Bill of Rights, they're about the criminal law mostly. Fourth Amendment, Fifth Amendment, Sixth Amendment, Seventh Amendment. These are about the criminal law. And it was important to our founders to ensure that you had these rights. And that's why we talk about them here.
Yeah, absolutely. Because, you know, there were times throughout history where you would get collected and you were forced to say something.
Right.
And it wasn't just that you were forced to say something when you were present with law enforcement, but if it went to a trial, you were forced to say something at a trial about whatever happened, whether it be against your interests or not. And so statements when stopped by law enforcement also goes, you know, it's not just with law enforcement, but, you know, you have the right by and through the Fifth Amendment to not make statements at a trial or a hearing related to your case. Now, sometimes, and this is a strategic decision, sometimes that needs to happen. Sometimes you need to get up there on the stand and testify and tell your side of it. But more often than not, in the vast majority of criminal cases, trials, and everything I've ever had, whether it's at a hearing or a substantive trial, the client or the defendant is not necessarily testifying.
Absolutely, the vast majority. And that kind of goes back to the first part, I will not represent myself in court.
Right.
There's a reason that the defendant is not testifying. And a lot of times it's to that person's benefit not to testify. Because it doesn't, we're not going to get too much into the weeds, but again, as Dylan pointed out, it's up to the state to prove something against you. Right? If you are charged with a crime, you're not there to prove your innocence. It's important. That's why we have when a jury renders a verdict, it's either guilty or not guilty. It's not guilty or innocent because you're not there to prove innocence.
Just joining us here on WTOB, this is For the Record with Greenwood Law. I'm Dylan Greenwood along with Harold Eustache on our last show of For the Record with Greenwood Law here on WTOB for a while. And we've been going through our Greenwood Law Bill of Rights and breaking down each and every part of it, where it comes from, why we tell you it, and let you know that this is something that, you know, these are your rights. These are your rights that you need to be aware of, because the vast majority of our interactions with the people that we work with have usually waived or disregarded their own rights in some way, when they could have asserted them. They could have used them to help them in their own case, and we hear a number of reasons why. Some people are worried about safety. They think by asserting their rights, they're going to make someone mad, and that by making someone mad, it might be more likely that they're going to get hurt. I've heard just a lack of knowledge. I've heard any number of things. Our experience is that it is okay to know and assert your rights. The important thing is to do it in a respectful way, in a way that is non-confrontational. You know, there's a big difference between you know, throwing in some derogatory statements, some cussing, and saying, yeah, I'm going to exercise bleep Fourth Amendment right. You're not going to search me, rather than saying, hey, officer, deputy, I hear where you're coming from, but I do not consent to a search of my car. I don't consent to a search of my person. And a lot of times we hear, well, you know, you're going to have to get a warrant. My recommendation when I hear that is always to say, well, then we can wait. Go get that warrant. I invite you to go get that warrant. And once I see a warrant, then, you know, obviously we're going to have to comply with that. But, you know, there's a way to do that in a respectful way versus being antagonistic. And so any of these times, our recommendation, if you are asserting your rights, be nice. Right. You know, it gets you get a lot more with honey than you do with vinegar, don't you, Harold?
That's right. And that goes to our fourth one, which is I will not consent to searches when stopped by law enforcement. Again, it kind of, this whole thing we've been talking about. You don't have to consent to a search. It is part of your rights, of your Fourth Amendment right. It is important for any state authority, be it law enforcement or anyone else, to get a warrant. And they have to have reasons and grounds for that warrant in order to search you, your person. And that means not just your articles of clothing and things on you, but also means inside your body via taking blood. They have to get a warrant to search your home or anything like that. And so it's important not to give consent. I mean, we see this so much where, somebody has, a illegal substance in their vehicle. Officer says, well, can I just look at your car? Can I search? The person says yes. And there you go, they're charged. Whereas the officer may not have had probable cause prior to that. And that person would not be charged.
Yeah, because I've had just the innocent case of, the parent that is driving their own car after letting their kid drive it the weekend before, and there's something that was left by the kid in the car, and they go, oh yeah, search, there's no problem. There's nothing, thinking that in their own car there's nothing, and then all of a sudden, there's like a leftover joint in the back seat. And then it's like, they're all of a sudden they're charged with a marijuana charge, and they're going, well, that isn't mine. And the officer's going, well, I hear that all the time. It's not mine. And, then all of a sudden, this adult is getting the marijuana charge when it was really their child's fault. And, it can be that innocent. At the same time, I've also seen video of officers, and they're rare, but officers who have placed stuff in cars.
Yeah.
And that does happen. And obviously, because they're dishonest people in all aspects of our life, including in law enforcement, including in our profession, whatever else. They're everywhere. And you do have those people out there. So just protecting yourself all the way around, from the innocent thing all the way up to the more conspiracy type thing against you, is definitely a good idea, because your Fourth Amendment right is probably one of the most important rights that was enumerated in our Bill of Rights. It is something that is debated about all the time. And there's a feeling that it is always sort of being chipped away at, especially in our digital technological based society. It's really easy to do that.
Right.
But I think now more than ever, it's important for people to know and assert and protect that Fourth Amendment right.
So our last on the Greenwood Law Bill of Rights is, I will not be my own star witness for the prosecution. And some of you may ask, what does that mean? Well, that means that your statements, don't let your statements that we've told you not to make, but if you do make them, be the thing that the prosecutor is holding up and saying, this is why you should be convicted. You're going to be your own star witness. You're the person that, because of your statements, that may lead to your conviction. You have the right to remain silent. It is your right. It's a sacred and cherished right. You have the right to not consent to searches, and so it's important that you not be the reason because of your statements or because of your consent to search that you could be convicted of something. And so that's why we're saying not be your own star witness at your own prosecution. And I know that none of our listeners want that, and we're hoping that you take this guidance about how not to be that.
So everyone out there, like we said, this is our final episode here on WTOB for a while, and we just want to thank all the people here at Greenwood Law, our staff that's been instrumental in helping put on our show. We definitely impose on our own office space to do this for everybody, and they've been very accommodating. We also want to thank Jessica Armentrout, family law attorney here at Greenwood Law, for providing great insight on family law related issues when we've had that as a topic for the show. And, of course, to all of our guests who have been able to join us. We've had some great people come on For the Record with Greenwood Law and provide a lot of great insight for them as well. And definitely want to thank all the people at WTOB for even just having us in the first place. We were contacted by Ken Hooser to get involved, and we appreciate him for reaching out, but definitely Bob Scarborough, who has produced this show from day one, given us a lot of advice and counsel and everything else, and we couldn't have done this without him. And so thank you so much, Bob. Definitely also want to thank Mary Kate Aponitis. She's helped make the YouTube iteration of this look as sharp as it does. All those graphics and everything, she's been great with that. And of course, to all of our listeners out there, thank you for joining us each Sunday at 10:30 a.m. On For the Record with Greenwood Law. We're going to dedicate this to the memory of my mom, Dr. Tamara Greenwood. Like I said, she has been a big part of what we've done here at Greenwood Law in making it a success. And so, like I said, we appreciate everyone out there, and remember that Greenwood Law Bill of Rights. And we've gone over it in detail today. And this is For the Record with Greenwood Law, signing off.